The crimes that are presented to the grand jury are what are called common law or malum and se crimes, things that are inherently criminal. The crimes that are presented to the grand jury are what are called common law or malum and se crimes, things that are inherently criminal.
Do you and each of you solemnly swear or affirm that you will true answers make to all questions touching your qualifications to serve as grand jurors in this court, so help you God, or under the pain and penalties of perjury?
Yes.
Yes.
All right, have a seat, everybody. Again, we're here today to select folks to sit on the grand jury. As you'll note, we have a court reporter, Debbie Moore, who's taking down every word that's said. As you'll note, we have a court reporter, Debbie Moore. You'll note we have a court reporter, Debbie Moore.
Show me Deborah Moore on the petition. Show me the name Deborah Moore on the petition.
Reporter, Debbie Moore, who's taking down every word that's said. So when I'm asking you questions, if you could please speak up and give us.
Without saying why, get up and walk out of the room.
Opportunity. So
Is my presence required here still?
Yes. Yes, it is, Mr. Myers.
For what?
Because we're in the middle of a legal proceeding.
All right.
Ms. Walker.
So we have that. It happens in grand jury. We don't ask the reason why, so we don't know why people feel that they can't be fair and impartial. Maybe they know the accused or one of the witnesses. Maybe it's just not the case for them. They could be fair on. But we ask that at every single presentation, and we drill that into you. And so we ask grand jurors to be fair and impartial.
You think you'd be okay?
I'd give it a shot.
Yeah, give it a shot, whatever.
In this case.
Right. Again, Mr. Myers, I don't know what the facts of this case are.
Why does it say victim?
I'm going to turn to Ms. Walker for some clarification. Ms. Walker.
Thank you, Your Honor. This is, Mr. Myers has been charged with interfering with judicial proceedings failure to abide by a court order. The alleged victim is Shannon Walker, the holder of that court order.
The holder of that court order. Okay. Court order schmorter. It literally says this is not a court order. And furthermore, this highlights the conflict of interest because look at all those fancy. She got to type her name. She got to check the box that says injunction against harassment. There's none of her actual writing on here. Now, here's what it looks like when somebody has to fill it out normal, like a normal person, somebody who's not the wife of a prosecutor. You see the difference there? You see the difference? And then also here how like she didn't have his address, but yet the courts do. I mean, Shannon does. Why would Shannon have his address? That's so weird. And again, it says this is not an injunction or not a court order. I mean, not a court order. Also, too, where it says relationship to, Shannon didn't put anything. She put other and then didn't describe it. And even if there were a description, and even if you do consider the contestation hearing where it's been upheld as a court order, he still put a appeal on that. So how can it be a court order if it's on appeal? It has not ever been a court order. So again, let's ponder how this is legally possible, right? All right, so the person has previously been convicted of an offense, including blah, 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 against the victim of harassment, right? Didn't happen. A court has imposed the conditions of release of the person that prohibits any contact with the victim of harassment, and the court order was in effect on the date of the offense. Okay, but in March 16th, it was still on appeal, right? And on top of that, mentions an injunction against harassment, but refers to it as criminal related. It wasn't. It was a civil injunction against harassment. And again, it can't be valid until it's upheld on appeal. And also, he didn't have any crimes against her in the beginning, so that can't even apply. It's ridiculous. And on top of that, relying on the grand jury transcript, which half of these crimes, like the first 14 of them, weren't even brought up to the grand jury. It was a direct indictment summons, right? they skipped the preliminary hearing part. So how can that be part of the agreement when it's not even a part of it?
Okay. Well, I just want to be, again, the crimes that are presented to the grand jury are what are called common law or malum and say crimes, things that are inherently criminal.
I brought this up months ago about this inherently criminal bullshit about, dude, okay, check it out.
His family.
A direct indictment is a legal process where a case goes directly to trial without a preliminary hearing or preliminary inquiry, which is a process to determine if there's enough evidence to proceed with a trial. This means that the accused bypasses the usual steps of a preliminary hearing where a judge decides if there's enough evidence for the case to proceed to trial. So they're bypassing that, right? So again, I ask, how is it possible that you can have the preliminary hearing as a part of the record? Direct indictment is typically used in situations where the prosecution believes there is strong enough evidence and/or specific circumstances that warrant bypassing the preliminary hearing. So it's where a prosecutor bypasses the grand jury and directly files charges with the court, which then can proceed to trial. So that's what a direct indictment is, right? You bypass the grand jury. And that's what she filed. So the defendant loses the opportunity for a preliminary hearing where this is the hearing where the judge would determine if there's probable cause to proceed to trial. So Rachel is just saying there's probable cause and nobody else is going to do anything about it. So can request a summons from a judge instead of an arrest warrant, especially if the individual is unlikely to flee or pose a danger. And again, there is no arrest warrant because I fucking, did a records request and there is none and there was none and there's, look. So here's when I screenshotted it before I sent it in. And then the 13th of April, here is when it was totally sent in. And then they answered me and it was a guy named Jesus. Crazy enough, right? And Jesus said, as a courtesy, I have checked the cases filed under Lane Myers, and upon review, no warrants were listed on the docket. So, nada. And they do put out arrest warrants. Here's just a random one to prove it. It says, it is ordered that the previously ordered arrest warrant is affirmed. So they do put out arrest warrants. And he was issued a summons. So by definition, he is unlikely to flee and does not pose a danger. So why would this be a thing? On March 28th, the state stated that the defendant was indicted on direct indictment and requested a summons with booking. That was not appropriate, as the defendant was in custody and being held without bond. The state asks that the notice of a supervening indictment issue returnable Friday, April 4th at 1 p.m. in PM County Superior Court. Why would she inappropriately do that? Why would she request a summons if his crimes were...
Or malum and say crimes, things that are inherently criminal.
So why at his arraignment was she asking for $25,000 and telling the judge that he was causing or would have caused harm to the alleged victim / this community? It doesn't make sense. Then it says direct indictment right after that, or a couple days later, or whatever. So why? So there's no finding of probable cause to summons him there. She skipped that, and then the direct indictment skips the grand jury finding the probable cause. She skipped that too. Why would you need to convene a grand jury at all if you can summon somebody and then just call for a direct indictment and just assume that there's or just declare that there's probable cause on both? Well, what's the point of a grand jury? Doing it the way she did it is a crime. And if for some reason I'm reading this wrong, then it really doesn't matter because it's only a misdemeanor if it's done before the person is in custody and Lane has been in jail for 38 days, so it doesn't matter. But what it does do is tell me for sure that an information indictment complaint is separate from a summons. It's not all one document. And since you've already got the summons, right, you should be able to tell or specify if this is an indictment, information, or if it's a complaint. But it literally just says the complaint, indictment, or information, and then it's the summons. They just put the summons header on top of it. What the fuck? And here's another huge problem that I have, right? This e-disclosure, right? Because a lot of these, well, when they disclosed the information or whatever, all of it had hyperlinks to the videos that were said to be the crimes, right? In which they looked something like this, right? Because we can't see them now, but this is what it looked like for the most part, right? And these were a couple of them. But the problem is, as a condition of probation, the court ordered to destroy evidence, right? And not even that Lane do it, that his probation officer do it, because he has control of the evidence. I mean, it's actual evidence, right? I mean, and the court is ordered, as a condition of probation, the probation officer is to have Lane destroy, or to the probation officer himself, because he has control of the account, right? To destroy the evidence. How can they do that? That's fucking insane. The only reason she can convene the grand jury is to get that fucking is because of this.
Again, the crimes that are presented to the grand jury are what are called common law or malum and say crimes, things that are inherently criminal.
I bet annoying phone calls is like number 2.
Assault, theft, robbery, sexual assault, arson, drug offenses, murder, aggravated assault, things like that.
Why did he leave out annoying phone calls?
So those are the kind of cases.
Okay.
All right. You think you'll be all right?
Yeah, I can do it.
Okay.
And one,
And then this jackass says, I assume the importance of this will be unveiled. Unveiled? Okay, how about this, buddy?
All right. Again, focused on the front row. Anybody else there? Let's see. Ms. Curiel?
Yes.
Yes.
I have a conflict with the time frame.
Okay.
I am currently employed for the Department of Defense, and I audit contracts, and I am currently, the current audit that I'm leading, and we've just recently been understaffed, and so that is going to end in October. And so although it sounds interesting, I would like to participate. However, because of the understaffing in federal agency, yeah, I just won't be able to do that.
So is there there's no one else that could step into that role and work on that while you're over here?
My supervisor to tell me no.
So your supervisor is trying to not be cooperative with the criminal justice system? Is that what you're saying? For the United States government? That's a little shocking to me. I'd like to have that person in here to question them. I bet they would have a very different opinion if they had to show up here and say that.
So I don't know if you heard, but she said she works for the DOD and she audits contracts, right? And then he said that. And then he says this.
I'll excuse you, Ms. Curiel. I don't want you to be punished for your boss's lack of interest in our criminal justice system.
Be punished for her boss's lack of interest in the criminal justice system. No, Metcalf, you are the reason for the lack of interest in the criminal justice system, or in some people's cases, like mine, for the interest in the criminal justice system to make it better, right? Because you are just garbage, bro. You see, Mr. Myers had people interested in the criminal justice system and was getting them juiced up about being a part of it. You know what I mean? And he actually has respect for what you do, which I'm sure he doesn't anymore. And you silenced 15,000 people who potentially gave a shit and were willing to be a part of your stupid ass system, right? So there's that. And on top of that, bro, in each of the areas, the limits of the unprotected category, as well as the unprotected character of particular communications, have been determined by the judicial evaluation of special facts that have been deemed to have unconstitutional or have constitutional significance. In such cases, the court has regularly conducted an independent review of the record, both to be sure that the speech in question actually falls within unprotected category and to confine the parameters of any unprotected category within acceptably narrow limits in an effort to ensure that the protected expression will not be inhibited, providing tiers of fact and with a general description of the type of communication whose content is unworthy of protection has not in and of itself served sufficiently to narrow the category, nor served to eliminate the danger that decisions by tiers of fact may inhibit the expression of protected ideas. The principle of viewpoint neutrality underlies the First Amendment itself. See blah, 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 blah. Also imposes a special responsibility on judges whenever it is claimed that a particular communication is unprotected. See blah, 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 blah. Here, the trial court effectively silenced defendant's possible participation in community debate by precluding defendant from mentioning plaintiff's name on any Facebook page. This is a prior restraint on defendant's freedom to express his opinions on political views. I'm sorry, political issues, right? While defendant's choice of words was uncomplimentary, including terms like as fucktards, idiots, and they suck, and the use of provocative language does not justify restriction on political speech. Much of the case law dealing with free speech relates to unthinkable speech that is advised by bigots, dissenters, and radicals, such as speech may be uncivil. However, this is precisely the types of speech that the First Amendment protects. You see, you may think you got away with it because in this particular case, the person was a politician, right? But politicians take an oath and hold office. Shannon takes an oath and holds office. And not only that, she admits that all this is because, and even the cop admits, it's all because of her husband, who is a prosecutor, right? A prosecutor that has ran for a judgeship, right? And there's been votes. It's actually been voted on. So if anything, it's silencing the political speech on political issues. It doesn't say on a specific person that is a politician, right? Right? It's silencing political issues, right? Like, for example, how her husband ran for judge and lost, 6-0 or whatever. You know what I'm saying? Like, it's a political issue, bro. Okay, see how this issue in 2022 was that Matthew Walker was running for judge and there was a 6-0 vote. That's political, right? That makes it political. So if he's silenced from his views on anything related to Shannon Walker or involving Shannon Walker, that means Matt Walker, right? You're silencing his political speech and everybody else's too that is scared as fuck to post anything about Shannon Walker or Matt Walker, right? Because there's some kind of victims of nothing. You know what I mean? That's what you're doing. You're silencing that speech, bro. You have a responsibility to catch this, right? And it's been brought up at every step of the way. And the injunction hearing, and emotions, and objections, every step along the way, the First Amendment has been mentioned, and you've ignored it.
All right. Next person.
Tyler Bartel.
It's usually just me during the orientation. I know that attendance is required, so I was wondering if I...
Who asked to be let off after this process starts. So it's kind of need to know now. So you don't, are there other people who volunteer? Is it a volunteer or a paid position? The time, it's okay. It's just you can't be gone for huge amounts of time. Okay? All right. I think, anybody else in the middle row? Okay, let's go to the front row. Yes, Mr. Romero.
Yes, Mr. Romero, a name that we don't want to hear. And what happens after that? They just cut the audio and everything.
Let's go to the front row. Yes, Mr. Romero. Sure. All right, well, I'm going to excuse Mr. Romero. Next person.
Melissa Sonyer.
All right. Again, focus on the front row. Anybody